Hello, everyone, and welcome to today's virtual event, the 2026 Supreme Court Review and Preview. My name is Megan Watson, Senior Associate Director of Alumni Relations, and we're so glad you've joined us today. Before we begin, I'd like to share a few upcoming alumni events. Our next Meet the Dean event will take place in Sao Paulo on June 10th, where Dean Chilton will connect with alumni and friends of the law school in Brazil. We will also host our annual Emeritus Luncheon on June 24th at the Law School, featuring Professor Allison Siegler. Professor Siegler will present a lecture titled The Fight to Restore the Rule of Law in the Federal Bail System, and discussed her work to advance fairness and due process in the criminal legal system. You can find more information about these events and other events on the alumni section of the Law School's website, or email us at alumni@law.uchicago.edu. Now let's turn to today's program. As the Supreme Court approaches its conclusion, today's program offers an opportunity to reflect on some of the most significant decisions issued by the court this year, while also looking ahead to the major cases that remain pending. Our faculty panelists will share their insights on the legal questions before the cases and discuss the broader implications of recent rulings and offer their thoughts on what we might expect in the weeks ahead. We are delighted to be joined by three of the law school's leading constitutional law scholars, Professors William Baude, Aziz Huq, and David Strauss. William Baude is the Harry Calvin Jr. Professor of Law and a leading scholar of constitutional law, federal courts, and statutory interpretation. He is widely recognized for his work on originalism and the separation of powers, and his scholarship is frequently cited by courts, scholars, and the media. Professor Baude is also a co-founder of the law school's Constitutional Law Institute and a regular commentator on Supreme Court developments. Aziz Huq is the Frank and Bernice J. Greenberg Professor of Law, and his teaching and research focus on constitutional law, federal courts, criminal procedure, and democratic governance. Professor Huq is one of the nation's leading scholars on democracy, executive power, and institutional reform, and his work has appeared in leading academic journals as well as major national publications. David Strauss is the Gerald Ratner Distinguished Service Professor of Law and Faculty Director of the Jenner and Block Supreme Court and Appellate Clinic. One of the country's foremost constitutional scholars, Professor Strauss is known for his influential work on constitutional interpretation and the development of constitutional law. He has argued before the Supreme Court, authored numerous books and articles, and is a frequent commentator on the court and its decisions. It is now my pleasure to turn the program over to Dean Adam Chilton.
Hi, everyone. I'd like to welcome both our alumni, friends of the law school, and the media for all taking the time to be here with us today. Now, one of the law school's great traditions is before the start of the Supreme Court term each year in September and October, we have a First Mondays event where we invite some of our preeminent scholars to give a preview of what they expect to see coming up in the Supreme Court over that year. Now, this year we decided to add something that's a little different. That is, in addition to the Supreme Court First Mondays event that we had back in the fall, to add an event now at the start of June to preview the remaining cases that are some of the highest profile cases that the Supreme Court has been yet to hand down that have been argued this term, as well as to review some of the things that have happened in the Supreme Court's term over the last year. So here's the game plan for today. Each of my colleagues are going to talk about two topics, I should say, in that cases. So a few of these span different areas. And then after they talk about two topics each, we're going to open up for Q&A, which can either be about the cases we've discussed or about the Supreme Court more generally. Now, I think it should be an exciting set of topics. We're going to be talking about guns rights, transgendered rights, immigration policy, the unitary executive, criminal procedure, and birthright citizenship. And so a range of high-profile topics today. The order is going to be first David Strauss, followed by William Baude, and then finally Aziz Huq. So from now, I'll hand it over to David. Please go ahead.
Thank you, Adam, and thanks to all of you for being here. I thought I'd talk about a couple of things. There are a couple of very high-profile cases before the court now involving transgender students, one from Idaho, one from West Virginia. And so I thought I'd give a little bit of background on those cases and what we can sort of, to the extent we can foresee what's coming out of those cases or the issues they might leave unresolved. And then after that, I thought I'd just say a word beyond that sort of general area, those cases and the subsidiary issues they raise. A word about a case, a quite different case in which the Supreme Court and Appellate Clinic, of which I'm a co-director, is co-counsel, a case that involves something called geofences, which is the use of cell phone data to identify where a person has been. So let me start with the transgender student cases. There are two of them, one from Idaho, one from West Virginia. Both of them involve laws that limit or prohibit the participation of transgender students in sports. The Idaho law forbids transgender students from participating in public school girls' sports, and the West Virginia law extends that to all schools and colleges. Here's a little bit of background on these cases. The Supreme Court's faced issues sort of like this before. There was a case called Bostock in which the court held that discrimination against a transgender individual in employment is sex discrimination. Transgender discrimination on the basis of transgender status is not explicitly prohibited by the employment discrimination laws. Discrimination on the basis of sex is. And the Supreme Court said, well, if you refuse to employ someone because they're transgender, that amounts to sex discrimination. The analysis is a little bit complicated, quite interesting, I think. Certainly could be criticized, but that's what the court held, I think, correctly, although I think it's a little bit more complicated than the court thought it was. That's part of the background. Another piece of the background is two cases, one quite recent, the other actually decided this term. There's a case called Skermeti, the United States against Skermeti, that upheld the constitutionality of a Tennessee law that forbade sex transition therapy of various kinds. And then a case called Childs against Salazar, just decided this term, which involved conversion therapy, the use of conversations, talk therapy to deal with someone who was thought they were dealing with various kinds of gender dysphoria. The court held that a law that forbade conversion therapy violated the First Amendment. So that's the background. The reason I was talking about that background a bit is that the feeling I got from reading the transcripts of the oral argument in the two cases that are before them this term is they really want to avoid thinking about the question whether those cases, the case involving those laws and transgender students in public education, whether those laws, it's more than public education, as I'll say in a second, whether those laws discrimination on the basis of transgender status. That's kind of the lurking issue back there. Do laws, A, discriminate on the basis of transgender status, and B, if they do, does that itself make them presumptively unconstitutional because someone being transgender is enough like the paradigm case of an impermissible form of discrimination, which is, of course, race. They seem to be the court seems to be quite determined is too strong a word, but if they can, really want to avoid that question and instead think about these questions as something involving something other than discrimination on the basis of transgender status. Whether they'll be able to do that for long is an open question. In fact, the DC Circuit just yesterday or the day before, in a pretty strongly worded opinion, condemned the Army for discriminating against transgender service members. So they may not be able to avoid that. But avoid it, they seem to want to do. So how do they avoid it? Well, in these cases, what was going on was in the background, single-sex sports teams, and everybody agrees that single-sex sports teams are okay. You can have boys soccer, girls soccer, boys baseball, girls softball. Those are not illegal, either under the Equal Protection Clause if they are engaged in by public institutions, or a piece I should have mentioned before, private institutions that receive federal funding are subject to Title IX of the Education Amendments of 1972, which forbids sex discrimination by educational institutions that receive federal funding. And the two cases before the court involve both the Constitution and Title IX. So the question is whether those anti-discrimination provisions, the Equal Protection Clause in Title IX, forbid discrimination on the basis of, forbid discrimination in those ways that transgender students can't participate in sports, in sports of the the gender with which they identify. Now, one of the issues in the case that makes it especially complicated and was the focus of a lot of the oral argument is this. There's no question that schools can have sex segregated sports. So in that way, sports is different from lots of other things where sex segregation would be questionable, maybe unconstitutional or illegal under Title IX. Sports, everyone agrees you can have separate girls and boys teams. And basically the argument of the people who were resisting the claim of unlawful discrimination was, if you have separate girls and boys teams, you have to have some criterion for distinguishing between girls and boys, right? And what better criterion than, chromosomes, sex at birth? To which the response was, well, but we're dealing with a class of people who have male chromosomes but have undergone a course of treatment that gives them no advantage or minimal advantage over girls and women in playing sports. That was the effect of their transition. So to exclude them from playing on girls' teams, you are excluding them from playing on a girls' team just because they have male chromosomes. Isn't that sex discrimination? That was the way the case played out. And you can see the counter argument to the one I just stated, and it was one that was prominent in the argument before the court, which is, well, what if you have a boy, someone who's unquestionably a boy or a male college student, and he's just not very good at sports, and actually he could participate in girls' sports, and he would not have any particular competitive advantage, not because he's undergone a course of treatment that mutes or eliminates the advantages he'd otherwise have from being born male, but because he's just not very good. Well, no one would say, well, he gets to participate in girls' sports, but isn't that what you're dealing with here? So that was the way this case sort of played out. And so I think one kind of theme in a lot of these cases is that the court really does not want to grapple with this question of whether transgender status is itself a troubling classification. They really want to analyze these cases in other ways. They present a First Amendment problem, or they present a problem about the regulation of practice of medicine, or they present just a straightforward issue about sex discrimination, and everybody agrees that there can be separate sex sports teams. So whether that seemed to be the way the court was going, that they will say, look, to the extent you have people who are born male who have suppressed the characteristics that would give them an advantage in girls' sports, they were still born male, they could still be treated as male as long as we are allowing separate girls and boys or men's and women's sports teams. You've got to make that classification. And that's a reasonable, sensible, good enough, depending on the level of scrutiny they apply, way to make this classification. I think my own view is it's unfortunate that they are putting off and hoping, I guess, to put off forever the question of, how do you treat transgender people? Or transgender people, have they suffered from the kind of history of discrimination and stigmatization that puts them in the same category as racial minorities? That's the question that they are trying to avoid answering, and I think they will continue to try to avoid answering it, but I don't know if they'll be able to do that forever. The case sort of related to that was decided this term, Childs against Salazar, was a case about so-called conversion therapy. Could a state forbid conversion therapy? That is to say, forbid the practice of counseling designed to persuade someone about his or her gender identity. The court saw it as a First Amendment case and said, well, that law is unconstitutional if you're trying to persuade someone in one direction about gender identity. You're not allowed to if you're trying to persuade them in the other direction. Yes, you're identifying as female, that's fine. Here are the ways you can come to grips with that self-identification in the face of various characteristics, biological and otherwise. That's okay. The law drew that distinction. It depends upon which side of the debate about about transgender status. You can't do that. That's viewpoint discrimination, a core violation of the First Amendment. That's what the court held in that case. Counseling in one direction is allowed, counseling in the other direction is not. We would not permit that in other contexts raising free speech issues. The issue there is, a line the court really didn't grapple with, which is we allow the regulation of various kinds of professional practices in ways that could be characterized as viewpoint discrimination. If you advocate one course of action to your client, if you're a lawyer, that might be okay. The opposite course of action might be malpractice, given the circumstances of the case. Is that viewpoint discrimination? Of course not. Why isn't this the same thing? And the court just elided that question. And I think the decision, while there are some sort of difficult issues in this area, I thought that decision really did not come to grips with that. Let me say a word about something completely different. I'm mentioning it really just because I think it's an interesting case, and also because it's one in which our Supreme Court clinic, as I said, was co-counsel. Case is called the United States against Chatry against the United States. Chatry, our client, is the petitioner. It involves something that's called a geofence. A geofence is a surveillance device that enables the government to see whose cell phone was within a certain distance of some object. So it tracks the location of cell phones. And in this case, the government got a warrant that allowed it to, there was an armed robbery at a bank, got a warrant that allowed it to get from Google information about all the cell phones that were within a certain radius of the bank. And then they narrowed it down to a smaller radius, and they said to Google, now tell us about the movements of some of these cell phones, and then finally zeroed in on the person that they arrested and used that evidence against them. They did have a warrant to get this information from Google. The claim by our client is that that warrant was not particular. The Fourth Amendment requires that a warrant be specific, and this was not. It simply said everybody within that range, and then narrowed it down in ways that were, again, not specific. The underlying issue here, and it's one they've confronted a couple of times, really going back several decades now, is we have a lot of Fourth Amendment categories that were developed in a pre-electronic surveillance, pre-digital world. And the question is how you adapt those to the world we now live in. So is wiretapping just like eavesdropping? Justice Black thought yes. A majority of the court in Katz against the United States thought no. You have to, wiretapping, unlike eavesdropping, is a search. Well, are these geofence devices that locate a cell phone, are they just like having a law enforcement officer standing on a corner watching who's going by and who's going into the bank? That's the issue. And the court in Chatry will have to decide at what point does a warrant become problematic because it allows the surveillance of a relatively large number of people. It's a kind of thing where I have a client, so I'm going to say they should say the warrants in this case, for instance, should be particularized. But in fact, it's an issue that implicates this problem that has been around actually for a long time. There are electronic surveillance devices in some of the foundational Fourth Amendment cases in the 19-teens. It's been around for a long time and will continue to be with us. So with that, I'd like to turn over the panel to my colleague and friend, Will Bode.
Thanks, David. I'm going to talk about two different topics the court still has pending for its last month of cases to get out the door, each in a pair of cases, one the Second Amendment and the other the Unitary Executive. And both of these topics and sets of cases are things where there are sort of continuations of areas of doctrine that the Roberts Court has become invested in and has been making quite a bit of law in. And both of them feature some, continued move in that direction and some questions about exactly how the court wants to work out the details. So the Second Amendment first. The court, of course, decided District of Columbia versus Heller almost 20 years ago now, where it first said that the Second Amendment to the Constitution protects an individual right to keep and bear arms that is not limited to military or militia service. For quite some time after that, the court said very little else about the Second Amendment and just let the lower courts deal with the predictable flood of cases that might come. Eventually, the court held the Second Amendment was incorporated against the states. And then finally, a couple of years ago in Bruin, the court, for the first time, really stepped in and tried to actually announce a methodology courts should use in deciding whether laws comply with the Second Amendment and the right to keep and bear arms. Specifically, the history and tradition, and basically that you should, all laws that on their face infringe the right to keep and bear arms are presumptively unconstitutional unless the government can show a history and tradition of regulating them, which the court argued is like what the court does in First Amendment case law, although many First Amendment scholars would tell you that's a sort of not accurate rendition of the First Amendment case law either. This has finally produced a lot of lower court disagreement. The court recently had to dip back into that in United States versus Rahimi, where it held that the federal law that stops somebody under a domestic violence restraining order from possessing a gun was constitutional, that the sort of lower courts have gone too far. And now the court is diving back in with two more Second Amendment cases. One of them, Wolford versus Lopez, is not a criminal case, but is a Hawaii property law, essentially. After Bruin made it clear that there is a general right to bear arms in public, Hawaii responded by trying to essentially flip the property default rule and say that it's trespassing. It's not permitted to carry a firearm onto private property unless you have the owner's affirmative consent or express permission. Many places have the opposite rule. So, throughout the city of Chicago, there are businesses that post signs saying no guns allowed in this movie theater, apartment building, etc., university, which are widely assumed to be constitutional across a huge range of businesses. But is it okay to do the reverse and say, until you hear otherwise, you can't carry a gun on private property, including gas stations, grocery stores, lots of places people might go in their daily life, making it hard to kind of just conveniently carry as you go about things. And interestingly, there are historical analogs to these laws. There are laws like this that made it a crime to carry guns on private property, both at the founding and during Reconstruction. But during oral argument, it became pretty evident the court was quite skeptical of a law of this breadth and was trying to figure out the best place to locate or describe its skepticism, whether it's by analogy to the First Amendment, where the court has expressed some skepticism about similarly broad default flipping rules to the First Amendment, whether it's to dig into the history and argue about what sort of specific Louisiana and New Jersey laws, really did or didn't say, whether that makes an analogy, or whether it's to, in a sense, nitpick the specifics of the Hawaii law. So the United States intervened as amicus to argue that it might be okay to flip the default rule, really categorically, but to do it in a sort of gerrymandered way where you make exceptions for various kinds of businesses and various kinds of gun owners reveals that something else is going on. The court seemed quite skeptical of that last approach, even though it would be the narrowest. So I think it seems likely the court's going to say something broader about the limits of the state's ability to regulate carrying arms in public, but that remains to be seen. The harder gun case the court has pending, or at least the one that's harder to predict, is a federal criminal case, United States versus Hamani, which deals with the federal ban on gun possession by an unlawful user of a controlled substance. And the question is both what does that mean and is it constitutional? The law also applies to addicts, which even the government basically agrees is unconstitutional, because if you are a person who has the property of being addicted but is not currently using a controlled substance, that's too close to a status crime. As I say, they mean it has to be somebody who's regularly using a controlled substance, and then they can't carry a gun at all. But how regular is regular? And again, is that so broad as to apply to the many millions of Americans who use medical marijuana or recreational marijuana in compliance with state law and in compliance with the sort of under-enforced federal policy and so on? And here, the fact that nobody quite knows what the statute even means does seem to have hampered the court's ability to decide whether it's totally constitutional. And so you saw a lot of back and forth, and sometimes slightly paradoxical arguments where the person challenging the statute wants to argue that the statute is very broad and their conduct is definitely criminal, so as to make the statute overbroad, And the government, which wants to save the statute, wants to argue that the statute is actually narrower than it seems. And while it seems likely that the court will not strike down the statute entirely on its face, there did seem to be a lot of skepticism at the court about sort of upholding a conviction on carte blanche, about saying that any amount of drug use is enough to make you categorically unable to keep and bear arms. But if I had to guess, I would guess the court ends up having to unite on something quite narrow, whether it's a remand or a holding based on vagueness or a series of sort of stipulated question marks about what exactly the statute says. So they both continuing to move the Second Amendment forward, continuing to find new things that they think the state can't regulate where it comes to guns, but also they're reaching the point where they don't feel comfortable articulating categorical rules that would lead to even more of a sweeping ruling than they're totally comfortable with. I'll say, while there's a lot that's controversial about, the court's foray into this area at all, and, whether the history and tradition are right to think about it, and whether the court is not paying enough attention to the consequences of widespread gun use, I do think at a meta level, it's good that the court is at least confronting cases like this, rather than sort of deciding one case every 10 years and then making the lower court struggle. I think it's actually good for them to take some of the cases where they have to struggle and move them a little bit towards common law articulation of what the rights actually mean. Okay. The other area where the court is doing something similar, maybe a little more definitive, although again, then forcing itself to get into the weeds of its own agenda, is where it comes to the unitary executive, which is the extent to which the president has an unregulatable ability to govern who else is in the executive branch. These cases have been going back for a century, really, where various officials have been, appointed or created by Congress with some kind of protection from presidential removal, and the court has imposed some limits on those protections and then upheld others. And this term in Trump versus Slaughter, the court appears to be poised to make kind of a definitive and final blow against the ability of Congress to regulate important offices. The case involves the Federal Trade Commission, which is the commission that was at issue in the Supreme Court in Humphrey's Executor, where the court said Congress is allowed to create independent agencies that are quasi-judicial, quasi-legislative, and quasi-executive, and therefore have some amount of insulation from each of those branches and are not directly controlled by any one of them. Humphrey's Executor has been narrowed and criticized by many members of the court over the past recent decades, starting from the Roberts Court about 15 years ago. And it seems likely the court will now finally overrule it and say Humphrey's Executor is unconstitutional when it comes to an independent agency or something else that's a principal officer. The president has to have the ability to remove them because that's an important incursion on his ability to execute the laws. Exactly how much further than that the court will want to go, however, is a little more complicated. So if you take the unitary executive logic to its extreme, say the entire executive really must be unitary, then you might think that extends to every single part of the executive branch, right? What about the civil service? What about the many, many inferior officers throughout agencies and line U.S. attorneys who are not even officers at all? And what about even more independent agencies like the Federal Reserve? In its cases so far, the court has, in a series of extremely ambiguous and unsatisfying footnotes, said or hinted that the Federal Reserve is different. It's different because it's in some way, if you squint, kind of like the first and second banks of the United States, which were in some sense independent. And maybe really it's different because the court thinks that having an independent banking system is really, really important. In a way, it doesn't think that it's really, really important to have an independent Federal Trade Commission. But a consequence of all that is that even the Trump administration has resisted pressing the argument that the Federal Reserve is totally subject to the executive branch. And instead, they've decided to try to play within the current rules. And so, as many people know, the president attempted to remove Lisa Cook from the Federal Board of Reserves on the basis of a somewhat pretextual-looking mortgage fraud allegation. And that case has now gone to the court as well on the question of whether or not she has received the necessary process and whether the government has supplied the necessary cause. Here, too, it seems likely the court is going to rule against the administration. It seems like they're going to say, as far as the unitary executive goes, it does not go this far. Again, in part because even the administration concedes that there is some limit on its power, and they're just trying to argue that they've presented cause, but in part because this seems like it goes too far, even for this court. And they might do that as a matter of substance. They might say, well, when there is some sort of protection from for cause removal, the cause has to be sufficiently weighty. It has to be maybe something that happened while you're in office, or something that really does interfere with your ability to do your job. Or even more limited, they might just say, we're not even sure about that, but we are sure that you need to have some sort of real process. If there are real restrictions, there have to be a real process so we can judge whether the real restrictions have been complied with. And here, where the administration has largely just sort of unilaterally made its own conclusion and relies on its own allegations, you might be able to say that process at least hasn't been demonstrated yet. Now, how much time that would buy the court, I'm not sure. Sort of like with David's remarks, it may be that the court wants to avoid having to get into exactly what kind of cause is required and what the limits are on Congress's power over the Federal Reserve, and it may not be able to avoid that forever, but it might be able to avoid it for a few more years. At oral argument, Justice Kavanaugh suggested that the court could draft a 2-sentence opinion in the case that says something like, process required, process not received, remand. And while I suspect the case will have to be a little longer than 2 sentences, it wouldn't be totally surprising to see a 4-page Justice Kavanaugh opinion that tries to say as little as possible other than, well, it can't be done this way. And with that, I'll turn things over to Aziz.
Thanks, Will. I'm going to address the 2 major immigration cases that remain undecided on the court's docket. The first concerns the removal of temporary protected status, TPS, from Haitian and Syrian nationals. And the second concerns President Trump's birthright citizenship order. I think it's worth noting at the beginning that immigration is not just distinct as a political matter. There's a reason that many of the shadow docket cases, as well as some of the major cases this term, are immigration cases, insofar as they reflect the tentpole priorities of the president's policy agenda. But immigration is also distinctive as a constitutional matter in ways that I think are evident to some degree in these 2 cases. And let me flag 2 ways in which that's so. First, at least since 1889, the court has not looked to the text of the Constitution alone as the source of immigration authority. Rather, in that 1889 case, Chan Che Ping, the court looked or found authority on the government's part to act on immigration in what you might think of as the brute fact of sovereignty itself. And that's led to or accommodated some paradoxical results, because in the immigration sphere, notwithstanding the fact that the court understands the government not to be relying upon a textually specified power, the court has allowed the government to do things that the government would not be able to do outside the immigration sphere, particularly when it comes to constraints on the basis of due process or equal protection. And the slide of authority from the legislature to the executive, which I think has been evident in many other fields, is much more acute in the immigration field than in other domains. So we have a very different kind of distribution of powers. That's the first point. The second point is that it's a truism that one of the questions that runs through almost all constitutional law is the who decides question. How is the authority to determine facts, determine law, in particular constitutional questions, allocated between the different political branches and the courts? One of the interesting things about immigration law is how the court's answers to that question are often the reverse of the answers it gives to the same question in other domains. So compare, for example, a decision from 2 years ago, SEC v. Jarkessi, in which the court limited an agency's ability to adjudicate certain civil claims, with a case from earlier this term, Urias Arella, in which the court limited courts' ability to second guess immigration agencies' decisions. So you have exactly the same kind of question being answered in different ways, certainly on principled grounds, but nonetheless a foundational question getting a different answer as we move from one field of civil enforcement to the immigration field. So I think those are two kind of framing dynamics that make immigration law distinctive. Now to the two particular cases. Temporary protected status, or TPS, is a statutory creation. It was created in 1990 in something called Title III of the Immigration Act. It allows initially it allowed the Attorney General. Now it allows the Secretary of Homeland Security, in consultation with, and I quote, appropriate agencies of the federal government, to designate countries as unsafe to return to because of war, natural disasters, or other extraordinary and temporary conditions. A TPS designation lasts either 6, 12, or 18 months. The default is that it's renewed, but there is a potential for it to be cancelled, although the cancellation has to be done in consultation with appropriate agencies. If you are a national of a state that is covered by TPS, provided that you meet other qualifications, such as not committing a federal or state crime, you are entitled, so long as the TPS status of the country lasts, to remain in the country free of deportation and to work subject to an authorization issued by the immigration authorities. Since the beginning of the Trump administration in January 2025, the Department of Homeland Security, acting through its secretary, this was largely Kristi Noem, has cancelled 13 of the 17 TPS programs. By my count, there are at least 9 suits. Depends on how you think about aggregate suits, the exact number. 9 suits challenging those cancellations in federal courts. In the lower federal courts, the challenges have been generally quite successful. However, they have been less successful in the US Supreme Court. The most important earlier case is one concerning the cancellation of TPS status for Venezuelan nationals. That has gone up to the Supreme Court from the Northern District of California on 2 different occasions. In both instances, the court has stayed an injunction issued by Judge Cheng of the Northern District of California. Nonetheless, Judge Cheng has ruled that the rescission was unlawful, and that case remains ongoing. The case that's before the court and the case that we will get an opinion from in the coming weeks concerns Haiti and Syria. And in the judgment below, Judge Reyes of the DC District Court found that the rescissions were unlawful for 2 reasons. First, that the rescissions were made on the basis of animus toward non-white immigrants. And second, because the rescission violated the Administrative Procedure Act. In particular, Section 706 2C. In the Supreme Court, however, the focus of attention is not so much upon the substantive grounds upon which the determinations or the rescissions of TPS status might be valid or invalid, because there is another provision of federal law that directs that there is no judicial review of any determination by the Homeland Security Secretary with respect to the designation or termination or extension of a TPS designation, right? So on the government's view, that language, I think that what the government would say is that language means what it says. If there is a lawsuit that is directed in any way to a specific TPS designation, it is to be dismissed for want of jurisdiction. On the other side of the ledger, the challenges to the TPS designation point out that there are earlier decisions. There's a case called McNary and there's a case called Reno, in which there was a similar jurisdiction stripping provision, which used exactly the same language of no review of a determination. And in both of those cases, the US Supreme Court said, well, what that means is that the substance of the determination cannot be challenged, but that challenges to the legality of the process by which the determination was made would be accepted. I don't know if it's entirely clear how the Supreme Court will come out on that question. There was some back and forth at oral argument about whether there is much light between a no review at all as opposed to review if only process standard. One of the most interesting moments, however, in oral argument was a comment by the Chief Justice, who raised a concern about the Solicitor General's reliance upon an earlier case called Trump v. Hawaii. Trump v. Hawaii might be understood as a case in which certain kinds of equal protection challenges to immigration decisions are ruled either non-justiciable or at least subject to a much weaker standard of review. And the Chief Justice said something along the lines of, well, you're quoting Trump v. Hawaii, Mr. Sauer, but surely that is not a case about non-citizens in the homeland, and to extend that case to this is to make a giant leap. Which was an interesting observation that struck me as important in as much as that equal protection issue seems to me very unlikely to be one that, at least in this case, reaches the court. Okay, birthright citizenship. In another executive order, 14-160, the president directed that birthright citizenship not be extended to people who were born in the United States, born physically in the United States, but whose parents were not either citizens or lawful permanent residents. Right? That I think is the kernel of the order, although the order it's a little more complex than my simplification. And the question presented in the slate of challenges to the order is whether that instruction, whether that limitation upon the scope of birthright citizenship is consistent with the citizenship clause of the 14th Amendment. The 14th Amendment citizenship clause, enacted in the wake of the Civil War, provides that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state in which they reside, right? So there's a constitutional provision that is self-executing there. There is also a federal statute that was first enacted by Congress in 1940 and then reenacted in 1952 that provides in basically the same language that a person who's born in the United States, subject to the jurisdiction thereof, shall be a national and a citizen. So in one sense, the Trump v. Barbara case, in which this issue is now fully before the court, as distinct from the question of or the earlier iteration of the birthright citizenship litigation, Trump v. Casa, in which the question was the availability of certain kinds of relief in the form of a nationwide injunction. The question before the court here is squarely one of constitutional interpretation. And all parties, I think, agree that the key language is subject to the jurisdiction thereof. And here's the government's argument. Look, the language subject to the jurisdiction thereof cannot be taken literally. It cannot mean literally what it says, because everyone understands and everyone accepts that there are certain exceptions to the birthright citizenship provision for people who are unquestionably birthed on the physical soil of the United States. The three historical exceptions are the children of foreign diplomats, the children of an occupying army, although that one, for obvious reasons, hasn't seen much use, and then Native Americans born on reservation land. So the government says, look, you can't take this STTJ language literally. It's got to mean something else. Over the course of the litigation, the government has taken different positions about what the something else is. Initially in the litigation, it argued that the test was one of what it called primary allegiance. It seems to have abandoned that position on the ground that nobody quite knows what the words primary allegiance mean, and they have no antecedents in the legal materials. And instead, the thrust of its argument, at least in the Supreme Court, was that the subject to the jurisdiction of language should be understood in terms of the newborn's domicile. And domicile of the newborn should be understood in light of the mother's domicile. And the hinge for this argument is a sentence in an 1898 decision of the Supreme Court called Won Kim R that does mention the word domicile. It is in that sentence, however, talking about the domicile of the child, not the domicile of the mother. Okay, what's the challengers' counter-argument to this? Well, the challengers observe that the sentence that the government relies upon in Won Kim R is buried in a paragraph in which the court states the larger principle that a person who is born in the United States, except for the 3 historical exemptions, is, by dint of the citizenship clause, a citizen. The challengers also note that the dissenters in the Won Kim R case, Chief Justice Fuller, and Justice Harlan, explicitly state, we disagree with this ruling because it treats everyone who's born in the United States as a citizen. So everyone at the point in 1898 seems to have understood that the case did not turn on domicile status. Moreover, there's no real doubt that Congress in 1940 and 1952 understood the citizenship clause in the broader rather than the narrower domicile-centered sense. So even if the government were to be correct about the scope of the citizenship clause in the Constitution, its argument with respect to the statute is substantially weaker. And then finally, the challengers argue that the best reading of the subject to the jurisdiction of clause is to say that citizenship follows soil and flag. That if you are born on US soil under in circumstances to which the United States has decided to extend its law, you are a citizen. Right? And the case of the Native American tribes, or members of Native American tribes, the case of children of diplomats, are both cases in which Congress could choose to extend plenary jurisdiction, but has historically declined to do so. Right, so that's the flag and soil principle is I think the best reading of the alternative. I said that the birthright citizenship cases are unlike the TPS case because it's about the text of the Constitution and the meaning of that text. However, there's another sense in which the two cases are alike, because I think that Barbara, like the TPS cases, at the end of the day is also a case about who interprets the Constitution. Because the court here has 3 options. The first thing that I can say is that it is the executive branch, consistent with this line of plenary power decisions going back to Chan Chi-ping. It is the executive branch that has the authority to decide on the scope and the meaning of membership in the national polity. The second thing that it could say is that, well, this is the role of Congress, notwithstanding perhaps what the court said in the Louisiana v. Calais opinion about the meaning of Congress's authority to interpret and give substance to the 14th Amendment. It is Congress that has that power, in which case I think the executive, in all likelihood, does not prevail. Or finally, the court could say, well, we don't really care what Congress thinks, and we don't really care what the executive thinks. We're just going to make our own first-order determination of what the Constitution, and in particular the Citizenship Clause, means. And if I had to guess the pathway that the court is going to take, I would guess that it will take that last pathway. I will guess that what we will get is a ruling not on the meaning of the statute, not on the ground of deference, but on the court's own judgment about the meaning of the word subject to the jurisdiction thereof. Let me turn it back to Adam now.
Thanks, Aziz. All right, we've got some questions already that have come in through the Q&A and also that were submitted in advance. So I'm going to try to just go through as many as quickly as we can. First question is to Will. Why do you think the Supreme Court may see the Federal Reserve as different in kind than the FTC or other independent agencies? And what is it about the Federal Reserve that leads to this kind of distinction?
Yeah. So I think there's a legal and historical answer, which is that the unitary executive is about executive power, and that executive power is about enforcing the laws of the nation, especially through force, which is something that the FTC and other independent agencies do. They bring enforcement actions. They can get damages against people. They can impose the law against people. And is not the core of what the Federal Reserve does, although the Federal Reserve does increasingly have a lot of regulatory power that it didn't used to, which is a wrinkle. The core of what it does is a monetary function that could be done by other private banks. I think that's the thing the court would say if asked. Even I am enough of a realist to think that there might be a different answer. And there might be a sense in which the court thinks the Federal Reserve has been functioning well as an independent institution. There really is, in some important way, above politics, and really does have a set of norms that would be made worse if politics were brought to bear on them. And that's just not true of most of the other independent agencies, for better or worse, that they don't have as well developed of a track record or as well developed of a real sense of something objective that the court cares about. And that could be an incorrect or benighted view on the court's behalf, but it's my suspicion of what's driving the answer.
Got it. All right, next, I'll go to David or Aziz with this. Are we seeing cracks in the collegiality of members of the Supreme Court? If so, what are they? And do you think that this will have any impact on the way that the cases are decided this term?
I think that calls for Aziz's diplomatic impulses.
All right, sure. Thanks, David. Ever since the leak of the Dobbs opinion, I think we've seen public evidence of frictions amounting to maybe more distrust than is modally the case among the justices. We've seen a form of that friction increase, or we've seen more manifestations of that friction in and around the criticisms that the justices, in particular Justice Sotomayor and Justice Kavanaugh, have either made or responded to in respect to the court's shadow docket practice, and in particular the unreasoned and non-precedential character of those rulings, in contrast to the apparent treatment by at least some of the justices of those same rulings as if they were precedential. So I do think that we do have extrinsic evidence of greater stress among the justices. I think it's also worth pointing out that in all certainty, both wings of the court, both the liberals and the conservatives, are acutely aware of the rising tide of threats of violence against members of the federal judiciary. They're, of course, aware that they are the most prominent and publicly known members of the federal judiciary, and therefore the most likely to be subject to those forms of violence. Obviously, Justice Kavanaugh has had at least one incident that has unfolded near his home, and I suspect that the combination of that background set of anxieties about the safety of the justices themselves and the safety of their families is combining with the set of stresses created by dealing with or confronting an administration that often resorts to non-traditional executive order forward, let's say, forms of policy making in a way that engenders the kind of shadow docket activity that we've seen, but also it engenders, in all likelihood behind the scenes, disagreement, not only first-order disagreement about the actual constitutionality or legality of the policies in question, but also second-order disagreement about how the court sustains its perceived independence, perceived authority with respect to the law at a moment at which that may be perceived even by members of the court as coming under pressure.
All right, next question. So we'll all go to you on this, which is I'm the question is how the use of the shadow docket has evolved over the last year. And for instance, a year ago when the Supreme Court decided Trump v. Casa on nationwide injunctions, there was at least a hope that this might lead to a reduction in the use of the shadow docket. Has that materialized, or have there been other trends that have moved forward?
Yeah, the short answer is it has changed a lot in the past year. So the first year of the Trump administration, the Solicitor General brought to the court several dozen emergency applications that the court felt some pressure to deal with in pretty short order. Some of them, like CASA, it managed to slow down some. Some are on the merits docket for this year, like the TPS cases and the Trump versus Cook case. But there were a lot of them, and it seemed like the justices were frankly struggling to deal with them well. The volume has shrunk a lot. I think that partly reflects the fact that the administration lost a few, and they have a very good lawyer, John Sauer, who has probably told the administration they have to be a little more careful about picking their battles. And probably also just reflects a shift in sort of the increase in how the lower courts are dealing with these things. There's still, several of these. There's been a recent slate of shadow docket activity around the 2026 elections and which states are and aren't going to get a green light to do rapid fire gerrymanders before the midterm elections. But it's gone from a sort of deafening roar to a dull roar.
All right. Does anyone else, actually, I'll ask if whether or not David or Aziz want to jump in on the shadow docket use.
Yeah, one thought on that, really just picking up on something Will said, which is a lot of the action about the shadow docket is really going to occur within the executive branch and between the Solicitor General's office and other people in the executive branch. Because especially when you have a president who is it seems to me out of control as this one is, there'll be a lot of pressure from other people to do something now, go to the Supreme Court, get them to overturn what this lower court has done to us. And it's really up to the Solicitor General and Solicitor General's office to try to hold that line. That's a recurring theme. That's just not distinctive to this administration. It's going to happen in any administration, that there'll be this pressure and counter pressure between the programmatic people who really want to get things done and the people who have to appear before the court all the time, who will say, if we keep doing this, when we really need something from the court, we will have cried wolf. So I think that that's part of what you're seeing is the Solicitor General maybe his deputies and lawyers in his office sort of finding their own feet and finding their way within the administration and putting themselves in a position where they can push back. So it's not really the court itself. It is the some lawyers in the executive branch anticipating what the court will do. That's the kind of key place in this dynamic.
All right, last question. What did we learn about the Supreme Court in the Terrace case earlier this term, Learning Industries v. Trump? And what also did we learn about the administration's willingness to comply with the Supreme Court in the months since the decisions come down? Aziz, do you have any thoughts on this?
I think that the learning resources decision was taken by many people as a kind of what's good for the goose is good for the gander decision, in the sense that a doctrinal innovation or a doctrinal evolution, depending on how you think about it, which is called the major questions doctrine, which had been seen as a generally deregulatory, generally, to put it in a coarse way, right-coded decision, generated an outcome that was left-coded, which was the striking down of at least the IEEPA tariffs. The other tariffs were not struck down. Another way to think about that ruling is you have a doctrine that is generally deregulatory, which is the major questions doctrine, and the court was able to leap upon the tariff case as an opportunity to cement that generally deregulatory doctrine into law over the objection of people who would normally resist it by applying it in an instance in which they find politically salubrious. In terms of how the the tariff decision has been complied or not complied with. I actually don't think that tells us very much about the Trump administration more generally, because the statutory framework for refunds of tariffs is complex. It depends upon whether the tariff has been paid. It depends upon whether the importer filed a threshold notice provision. And it is my understanding of the post-learning resources litigation that I believe is concentrated in the Northern District of Illinois. The complications there flow from the fact that we have a reticulated remedial framework, which is awfully difficult to apply to a whatever it is, $1 billion tariff backlog. I don't think that tells us very much about the general attitude of the administration to compliance.
All right. And I think with that, we're out of time and we'll stop there. And thank you, all three of you, for this. And I'll hand it back over to my colleague, Megan, for concluding remarks.
Great. Thank you all again. Thank you to Dean Chilton, Professor Strauss, Professor Bode, and Professor Huck for sharing your time, expertise, and insights with us today. And thank you all of you to joining us virtually. As always, we look forward to welcoming you back for our annual First Monday Supreme Court preview program in early September, when a distinguished faculty panel will offer insights and perspective on the Supreme Court's cases in the upcoming term. With that, have a wonderful day, and we look forward to seeing you all at a future law school event soon. Thank you.
Thanks, everyone.